Art and listed buildings. I'm Clarissa Levy, Art and Heritage Counsel at Wedlake Bell.
And I'm Richard Harwood. I'm a barrister at 39 Essex Chambers.
And this morning, I'm absolutely delighted to say that this is a long overdue moment when Richard is going to be answering all the questions. Richard, in all the years that I've known you, I've long appreciated being able to come to you with basic questions about listed buildings and art and listed buildings. And my preparation for this podcast was reading your book again, Contested Heritage, Removing Art from Land and Historic Buildings. And since you are the authority, I'm going to just be reprising my lifelong role of asking you the very basic questions and looking to you for all the answers. So I suppose the first one is always, what is the connection even between art and listed buildings? What have they to do with each other?
To give one example, there's a Lucian Freud mural which he painted on one of the walls of his country house, Coombe Priory, back in the 1950s. And some 50, 60 years later, the mural appears being offered to a London auction house. And what had happened was that a subsequent owner of the house, who then sold the house on, had decided before selling the house that he would have the mural very carefully, very professionally removed from the wall and would seek to sell it. The problem that prompted was that the house, Coombe Priory, was a listed building. It had been listed not actually anything to do with Lucian Freud or to do with the mural, but because it was a Jacobean house. And the issue that then arose is, well, was a listed building consent required to remove it? Now, that's a matter that went quiet for a few years, and then an article appeared in the Salisbury Journal with the local authority saying very delightedly that they arranged for the return of the mural to that particular house. So I think the reasonable assumption is that the view had been taken that listed building consent was required to remove it, hadn't been granted, wasn't going to be granted, and so
they had to stick the mural back on.
Which was probably better news for the person who bought the house from the guy who'd removed the mural than it was for the person who removed the mural. So there are occasions when the status of listed building actually becomes important to what you can do with an artwork.
Yeah, of course, because works of art can clearly be part of a building. So when it's a listed building, works of art can be part of a listed building. Okay, so far so good.
And there's a few, but I think what you have in mind is what are listed buildings? They are buildings on a list which is prepared by the Secretary of State or by other ministers, which are buildings of special historic or architectural interest. So it's concerned with a building. And that, what is a building, we'll come on to some of the aspects in a little bit. But firstly, you're either caught by the regime if what you're dealing with is a building on a list, or it comes within what's referred to as an extended definition of objects which are fixed to the building or within its curtilage, so land associated with it. So there's a few different ways in which the listed building regime may interact with artworks.
Why are we concerned? Why are we concerned with what listed buildings are?
Well, because if you do works to a listed building which affect its special interest or amount to demolition, then listed building consent is required from the local authority, potentially on appeal from the minister for doing that. So the removal of an artwork, if it's part of the listed building one way or another, may well require listed building consent, and either you go through the process and get it, or that may prove to be difficult to do. So it has an effect on the ability to sell the item. It has an effect potentially, if you do sell the house, what you can take with you and what you have to leave, and can also have an impact on valuation. So if we're dealing particularly with sort of inheritance tax valuations, the value of an artwork may be very different if it is something which can be just removed from the property and sold, or it's something that has to be kept with the house.
This is something I'm very familiar with, and it goes back to the origins of the time when I first started asking you my questions, when I worked at an auction house, and sometimes people would come and want to know if they could sell something out of their house. And if their house was listed, then that was even more complicated. But always the question was the same. Are you allowed to remove this thing? Can you sell it? Or is it part of the building? And of course, that has a huge effect for the value, because if you can't sell something, obviously it's valueless to you. But also, even if you have removed the thing and you want to do something with it, like, for example, pay a tax bill with it, offer it in lieu of tax, and have it remain in that building, you can't do that thing if it's actually part of the building and it's not just a kind of freestanding work of art. So it's a really vital question. And opinions would differ because it makes such a dramatic difference to the owner.
Yes, and I think some cases ultimately relatively straightforward once we sort of work through the principles. Some are matters of balance and to a degree matters of impression. I think we'll come on to some of those where what you do have to do is to sort of look and see the item in its context. And it's sometimes difficult to take a view without having done that. Sometimes information on the paper is more than enough.
Well, now we're going to get into even more of the lawyerly stuff that I love so much, which is this. When is an artwork not an artwork? When is an artwork a building?
Well, the definition of a listed building in the only bit of legislation I will mention is in the Planning, Listed Building and Conservation Areas Act 1990, Section 1, Subsection 5. It's a building included on the list, and then there's an extended definition of things that actually we'll come to, but building included in the list by the Secretary of State. This arose very prominently in a case which went all the way up to the Supreme Court, a case I was in called Dill and Secretary of State. And what that concerned were a pair of lead urns which stood on limestone slab piers, a bit under 3 meters in height. A pair of those, and the urns had originally been attributed to the Flemish sculptor John van Nos in the start of the 18th century, and those had been at Rest Park, which is property of the Duke of Kent. Rest Park went into private hands, subsequently sold in 1939, and the family who sold them took those urns and piers and a variety of other things, sundial and things like that, from the garden and sort of moved them around various houses in the Midlands along with them. So they move house, take all the garden stannery, stick it somewhere that looks quite convenient. Finally, they moved to Idlicott House in Warwickshire. And something Idlicott must have made a listed building before they arrived. 1973, they arrived, put the urns and piers either side of the driveway. In 1986, the Secretary of State added the urns and piers in their own right to the listed buildings. Not clear what happened, but that wasn't either not communicated to the family or not recalled. And in 2009, the piers and urns were sold at auction. About 5 years later, the local authority finds out about this and issues a listed building enforcement notice requiring the return of those piers and urns. And it's served on the owner of the property, Marcus Dill, who's from the family who'd originally been at Rest Park.
But very unfortunate because Marcus Dill no longer has the urns because they were sold years ago.
They were sold years ago. No one quite knows where they were. It seems to be taken out of the jurisdiction. So he appealed to an inspector, and one of the grounds of appeal was that these were not actually buildings.
So the urns are not buildings.
Urns were not buildings. So even though they were put on the list, they weren't actually buildings. So could not be a listed building. So no offence committed, no breach at all.
Wow. So, but they were listed then, what, in error? Or they were listed on the basis that they were buildings?
Yeah, the one would be listed in error. And the inspector and the High Court and the Court of Appeals said, well, they're named on the list, you can't go behind the list. The case that we then appealed to the Supreme Court. Supreme Court said, first of all, yes, you can go behind the list. It's either a building or it's not, and the inspector should have considered that question. And the other point the Supreme Court go into is, well, what is the question? What is it that the test you apply when one is a building? And the Supreme Court said it, drawing on some planning and rating cases, you look at size, you look at permanence, you look at the degree of attachment to the ground. And also, Lord Carnworth, who gave the reason judgment, said, well, listed buildings have significance in their context. The location that's important. And also, if you're looking at demolishing a listed building, you're looking at the concept of dismantling. So taking something apart. So the fact if you can just move it in sort of one or two pieces without breaking it up, that may be of some bearing. But size, permanence, and degree of attachment are what matters.
And the urns were insufficiently large and attached.
Well, the Supreme Court said, well, actually, that's a question for the inspector. Going all the way back to should have asked and looking at the facts and so on, is for the inspector to have dealt with that question rather than the court. So didn't express a view. Courts did say that, look, this case has been going on so long that really the public authorities should just drop the enforcement notice, which ultimately happened. Does mean that there's actually, a bit like whether or not in Donahue and Stevenson, there was a snail in the ginger ale bottle, not resolved whether the urns at Idlicott were buildings or not, which makes it a great question for students, but one which we don't actually have the answer to.
Well, all right. Okay. So undecided whether or not the urn is a building. But if it's not a building, can a work of art, like a sculpture, like an urn, be part of a listed building?
Well, potentially. There's two sort of routes into that. First of all, if it's something that's fixed to the building, then it would be seen as being part of the building. And that applies to an object or structure that's fixed. So it's these ancillaries. So if you've got terrace houses, you're not all going to be caught by the listing, but we're looking at potentially artworks. They could be an object or structure.
So like a work of art that's nailed onto the side of a spectacular building?
Possibly, or perhaps a spectacular work of art, which is attached to an otherwise not terribly interesting building, which makes the building a special interest in its own right. But the test to apply, first, is it's affixed to the building. And the court said, don't look at is it a building test, but tests derived from property law, which is looking at the purpose and degree of annexation of the item. And listeners may remember that, Chris, we discussed that topic, all the property law cases, with David Sawtell in a podcast episode called Art and Land. And there are lots of cases of Victorian heirs behaving badly and wrecking the place, and so on. It goes all the way through to sale of items, case of Berkeley and Poulet, as whether paintings and statue of Greek athlete were part of the land, to the case we all love to talk about, which is Old Flow, about a Henry Moore sculpture. But you're looking at purpose and degree of annexation, and the way in which that, well, it matters, it is the purpose, the connection with it. And this, the building sense, came up, first of all, actually in a case before the statutory definition was as it was at the moment, the case of Cawthorne, which was about a property called Scarisbrick Hall. And there were a variety of wooden panels and wooden sculptures of St. George and so on in this property, which was being sold to become a school. And the issue was the local authority sought in listed building control terms. Regime's a bit old, David, don't need to go into detail of that, but a question in listed building terms, whether these particular things were part of the building. And the High Court said that the property law approach applies, the purpose degree of annexation. These were part of the buildings. Lord Justice Russell, who is a judge there, did sort of add that having found that they needed then to stay there, was that one of the consequences was that the preparatory schoolboys at Scarisbrick Hall would be more fully appraised of the genius of Gothic revival at no extra expense to their headmaster. So that's all right then.
Obviously a vital part of any schoolboy's education.
Absolutely. Well, I think we have to agree on this podcast. The Gothic revival is important to education. So that was one case that looked at that. And it's come up in some cases. Usually it's sort of decision of planning inspector level. One very prominent case is the Time and Life building, which is at the junction of New Bond Street and Bruton Street. And it was past, it will have seen some sculpture on the outside, clearly part of the building. But there's quite a lot of sculpture, including work by Henry Moore inside, which the planning inspectors, after one or two High Court cases on that case, ultimately resolved were part of the building because they were part of the design. And that's important on these items, which is that often you are going to fix an artwork, a painting, or what have you, because otherwise it's the risk of falling off or somebody might nick it.
You're going to fix it sort of fairly securely to the wall.
Yeah. And so whilst that's important to look at it, on one occasion I was dealing with a situation where we were looking at whether an item could be given an acceptance in lieu. I was sort of leant forward towards this Van Dyke, and the whole team behind me also leant forward. I was looking to see what it would connect to. They leant forward to make sure I didn't knock it off the wall. So attachment is part of it, but it's the purpose of an artwork being attached is often simply to appreciate the artwork. And so generally speaking, paintings are not seen, which are sort of hung on the wall, not seen as being part of the building. But there may be situations where a room has been designed as an Italianate style or Tudor style, and the paintings are very much part of that room design.
What, because the room was designed specifically to show off the art?
Or the room was designed to have a particular feel to it, and the paintings were part of creating that feel, that style to it, which happened in this building case at Knowsley Hall, where a very Italianate style had paintings which matched, and the paintings were seen as being part of the design of the room and so part of the building.
I mean, it feels really difficult now. It feels much less clear than it was in my head to begin with, because any scheme, any decorative scheme of a room is always going to take into account the objects, the decorative objects, as well as the style of the room.
And it's picky because, of course, if you're looking at buying an artwork, you're often going to be thinking, well, I've got this room which I need to do something with, or this wall, or finding out where will it fit in to my property.
You're not going to decorate a room or a house with art that just really doesn't look good and isn't shown off to best advantage. So it feels like there's going to be a bit of a presumption towards it being part of the building.
Yeah, I think there is that interrelationship, and it's difficult to completely separate. You don't put artwork somewhere randomly, really. But the general trend on the cases is that paintings, leaving aside murals, which we can see as being part of the wall, but paintings, generally speaking, are not going to be seen as part of the building. In the same, the property law cases tend not to do that. So where the design of the room, how the painting's integral to it, is, I think, very much more the exception than the rule. And I recall one occasion visiting one property where you could see from the paintings why the owner who had designed this room had got those paintings in. He'd put all his heroes in and so on in the artworks around that. And it just sort of struck me as being, this is very much part of, paintings are part of the room. Tends not to be the case. So with paintings, it's very much sort of the exception. Very different where you have things which are fixed in quite firm, like overmantels, and most obviously something like a fireplace or
murals.
Murals which will be painted onto the wall or mosaics tiled onto the wall. They are very much part of the building. In a sense, if you're thinking, one way to put it in mind is if you were buying or selling the property, would you expect them still to be there when the sale happens?
Although that's another very difficult question.
Very difficult question. It's the same. I mean, legally, it's really the same question. It's the property law, purpose and degree of annexation question. And sometimes it's quite tricky, yeah.
Let us take ourselves outdoors. What about garden statuary?
That can get covered in two potential ways. One is being listed in its own right, which is the issue in Dill. The other is that the definition of a listed building, the so-called extended definition, includes objects or structures which are part of the land and are within the curtilage of the listed building.
What is curtilage?
Curtilage is, I best described as land which is part and parcel of a building.
What, the bit of parkland around your house?
Possibly. Depends how big your house is and depends how big your parkland is. So the very easy sort of example would be an urban house with a driveway and a modest garden and so on. And broadly speaking, you'd say, maybe exceptions, but broadly speaking, you'd say, well, all that garden, land and driveway and so on is within the curtilage of the house. It's part and parcel of the house. When you come to a big country house, it gets a bit more difficult. You have the immediate properties, sort of the stables around it, very likely, garden, kitchen garden, very likely.
Yeah, and then you've probably got a little bit of a water feature elsewhere with probably a grotto and some nymphs and stuff.
Yeah.
Is that part of the curtilage?
Possibly, depends. I mean, the parkland beyond could be, might not be. The rest of the estate I think the thing in mind is curtilage as a concept attaches to buildings. It doesn't attach to land ownership. So if you've got a sort of farming estate beyond the country house, the fact it's in the same ownership or even the same occupation probably doesn't bring within the curtilage. So it's the association with the building.
And what do you do if you want to sell a work of art from the estate and your building is listed? So in other words, can you have consent to remove the work of art?
You can potentially. I mean, the first question, of course, is do you need consent? So is it part of the building? And often, if there is a genuine issue, that can be resolved informally with the local authority's conservation officer. But if it is part of the building, are you affecting special interest by removing it? Quite often, yes, particularly if you're dealing with an item that's been in the building for a long time, might not be original to the building, but has been there for a long time. So let's take one example of a chandelier in the chapel of an almshouse at Kirkleafen, where the chandelier had been there since the 1730s. And I said a little bit of arguments whether or not consent was needed, whether or not the connection to the chandelier meant it was part of the building. And anyone who wants to study how chandeliers are sort of attached. So the inspector took the view that it was part of the listed building. He did in that case grant listed building consent, and that occasion with two reasons. One was that, in fact, this chandelier, which is a wooden Baroque gilt, a very gaudy, really, chandelier, was a bit sort of out of keeping with the rather the Palladian style of the chapel.
Oh, so he was really judging the style?
In part, it's a bit out of keeping, and it was going to be replaced by a less expensive chandelier, but a good one. And also, the funds which would come from the sale were going to be used to help keep up the listed buildings of the almshouse. So there was a rationale for it. But I think if you're in a situation where you do have an artwork which is part of the listed building, so that removal needs consent, then securing the consent for removal can be difficult, because the presumption with listed buildings is that they will be preserved. And removing items which are part of their interest, their special interest, is generally going to be seen to be harmful. And that needs to have public benefits which outweigh that harm.
I see. So that's why they can take into account the very subjective questions which you've just outlined of why are you removing it? What are you removing it for? What are you doing with the money? As if that was part of the question of whether it's a part of the building or not. But I suppose this isn't about whether it's part of the building. It's about whether it can be allowed to be removed. And if what you're going to do is, I mean, in the view of the inspector, a good thing for the rest of the listed building, then maybe they'll say on balance, fine.
Quite possibly. It is a matter of judgment. I mean, one case involved Osburton Hall, where in the sort of the main hallway of the hall, so to speak, display cabinets being put in the 19th century with a very extensive collection of stuffed birds. So by one of the country's leading taxidermists had done the work on that. And roll forward 100 or so years beyond that, the owner's family who live there don't like the birds. Their children get scared by them. I've seen some photos. I can understand, boy. Yes, sure, but seek listed building consent for the removal of those with the intention of finding them a home for them. But the inspector took the view, I mean, it seemed to accept that they were part of the building, took the view that there was harm from the removal of those, and what was being put forward wouldn't have amounted to a public benefit to justify the removal, particularly as the assembly had been collected for that particular property. So if you do need listed building consent, it can be quite difficult to obtain that.
That is something I didn't know. I didn't know you were allowed to take into account sort of decisions about, well, as you said, back to the chandelier, was it in keeping with the rest of the building? So perhaps if you'd got an inspector who was not so keen on stuffed birds, then it might have been a different decision. We'll never know.
Quite possibly. I think with a lot of decisions on the merits, there are matters of judgment, and that does come down to the individual authority or to the individual inspector, and also very often matters of balance between the harm and the benefits.
In matters of judgment and of balance, Richard, you are, as always, the only voice I will listen to on this question. So thank you so much for once again your patience with my questions about listed buildings and art. That's been really interesting. And I would like to say I'll never have to ask you any further questions about it, but we both know that's not true. Thank you so much.
Thank you for listening to the Art and Heritage Law Contested Heritage. Please do follow or subscribe on Apple or Spotify podcasts to enjoy more shows.
We have a new podcast out every fortnight. If you're able, please take the time to rate us and put down a review.
The show is also on the 39 Essex Chambers website, along with podcast series on topics such as artificial intelligence, climate change and planning.